and welcome to the 30 years 30 Court of Justice of the European Union cases, a series of podcasts launched by ERA Academy of European Law. My name is Kleoniki Pouikli. I'm environmental lawyer at ERA, and today we're discussing a judgment which dates back to 1992. It's the C-2 1990 Commission versus Belgium, which is commonly known as the Walloon Waste case. In a nutshell, this case was concerned with a Belgian law that prohibited waste that originate in member states from being dumped or stored in Wallonia. The question brought forward to the European Court of Justice was whether this provision ran counter to the Article 34 of the Treaty on the Functioning of the European Union, ensuring the free movement of goods. This judgment unveils the challenges in striking the balance between environmental protection and the legality of quantitative restriction on waste import from other member states. These difficulties posed by this case, both legal and political, were evidenced already by the court's unprecedented step of reopening the oral proceedings twice, as well as the Advocate General issuing 3 separate opinions. Today, we will revisit this landmark ruling with our guest expert, Professor Hans Wedder, who will briefly navigate us through the most salient legal issues addressed by the court. Very briefly, Hans Wedder is Professor of Economic Law at the University of Groningen in the Netherlands, and his research and teaching interests include European and Netherlands competition law, European environmental law, economic law and energy law in particular, and the relation between economics and economic law in general. Professor Wedder, welcome and thank you for joining us today.
Thank you, Kleoniki, for introducing me and for also allowing me to participate in this very nice series of discussions on beautiful cases. Because indeed, Walloon Waste is a fun case. It's a fun case to explain to students. It's a fun case where you can connect an older case, let's face it, 1990 is pretty much a case from the history, and you can connect it to current problems, the problems that we still see shaping EU waste law as we speak. So the background, and you've already explained this also, this is actually a treaty infringement procedure. So this is the Commission versus Belgium, because the European Commission considered that Belgium, by adopting this decree that prohibited, in short, the dumping of waste not originating from Belgium within the region of Wallonia, that decree infringed the waste shipments, the waste framework directive, as well as the free movement of goods. Now, on the waste framework directive, the court made short shrift and basically said there is no problem there. So what the Belgians did is okay with secondary EU waste law. Also because obviously the Waste Framework Directive doesn't touch upon the free movement of waste. It just tells member states to basically organize their waste treatment in an environmentally sustainable manner. That's it. Then the Commission's second line of reasoning for finding fault with the Belgian rules was the infringement of the free movement of goods. And that's actually where the court takes us through the motions of the free movement of goods. So first argument put forward by the Belgians is, but the free movement of goods doesn't apply. And then the court says, yep, no problems here. Waste is a tangible subject, so it's within the free movement of goods, and the mere fact that, well, the payments are, let's say, counterintuitive, because mostly people will pay for waste to be shipped, and in this case, landfilled in Wallonia, and the fact that you don't pay for the good, but actually get paid to process the good, doesn't rule out the free movement of goods, the applicability of the free movement of goods. Actually, it does raise an interesting point, because in a way, it would have been more sensible to deal with this case under the free movement of services, because what's actually at stake is not so much the waste being transported, but rather the service for waste treatment, waste landfilling service being required, possibly also in a cross-border contract. But okay, we can return to that later on. For now, the point is, yes, this is a free movement case, and the court finds a restriction on the free movement of waste, because this rule quite simply prohibits the import of waste from another member state into this region of Belgium. And we know that if something is a restriction on free movement, then it needs an objective justification. And that's where the court, in a way, paints itself into a corner, but on the other hand, also shows good insight into the intricacies of waste law. Because what the court says is that waste is a good of a particular nature. It's a good of a particular nature in the sense that it creates a health hazard. It creates an environmental health hazard even before it constitutes a health hazard. This is paragraph 30. So what the court then does is it basically says, before you have an Article 36 case, so before you can rely on the protection of the life and health of humans, animals, and plants, the justifications listed in Article 36, you would have an environmental case. And environment is not in Article 36 as such. So what we need is the CACIS imperative requirements, or the rule of reason, whatever you want to call it, and this line of court cases where the court has said any good argument that is acceptable to the European Union can also justify restriction on the free movement, in this case, the free movement of goods. And from the Danish bottles cases, we know that protection of the environment is one of these imperative requirements of EU law. So the court went on to justify this case, not on the basis of Article 36, but on the basis of this rule of reason, CACIS justification, whatever you want to call it. Now, we know from the cases that there are 4 requirements to be met for a national measure if it needs to be objectively justified under this CACIS rule. So you need to have your CACIS imperative requirement. You need to have a non-discriminatory measure. The measure cannot go beyond what is necessary, and it needs to be adopted in the absence of EU law. Well, the absence of EU law in this case was no problem. We didn't have EU rules on the free movement of waste, so there was no harmonization. We also have an imperative requirement. The court explicitly acknowledges that waste, even before it constitutes a health hazard, presents a risk to the environment. And that's where the Commission points out, but hey, this is a discriminatory measure. If the Wallonian government were to be non-discriminatory, it would have to block the import of all waste and not just waste from another member state. And that's not what happened. This is a case that distinguishes between waste generated within Belgium and waste generated in another EU member state. And that is, whatever you want to call it, a measure with distinction, a discriminatory measure. Anyway, it's problematic. And that's where the court does something really interesting. And it's also something that in a way continues to puzzle us, as the advocates general have noted, compounds to tortuous reasoning, problematic reasoning. But the court says, well, precisely because of the special nature of waste and because of these waste law principles of proximity and the source principle, actually, waste coming from abroad is not the same as waste being generated within a member state. And that's why the court says there is no discrimination, so the measure is okay, compatible with EU law. It is objectively justified, which obviously omits one further criterion. That's good old proportionality. The court did not review proportionality, the proportionality of this Belgian measure in this specific case. So lots of legal issues, and they're all tucked away in small paragraphs. It's a relatively compact judgment, but the basic point of departure here is this. Well, basically the 2 sides of the coin. On the one hand, it's possible to objectively justify such a restriction on the free movement of goods using environmental protection, so taking it outside the protection of the life and health of humans, animals, and plants, the Article 36 grounds. On the other hand, this reasoning whereby the court says it's not discriminatory because it's waste, and the fact that the court omits the proportionality assessment.
Thanks a lot for this first summary of the highlights of the legal, which highlights the legal problems within this case. Should we maybe start a little bit digging into more of the topics that you already touched upon? So first of all, there was a big discussion in one of the questions relating to the qualification of waste as a good, which was also part of the decision of not selecting the free movement of services, but falling in within the free movement of goods. And questions relating to the fact whether movement of unusable or non-recyclable waste should be covered by treaty provisions concerning the free movement of goods, given that this type of waste do not have any commercial value.
Indeed, that was the Belgian government's first argument, so that waste which was not recyclable, not reusable, could not be regarded as goods, because that's indeed where you would be paying the recipient entity, so this Walloon landfill site, where you would be paying them to actually process these objects for you. And that's where the court says, well, basically, we cannot entertain that. This distinction would be difficult, if not impossible, to apply in practice. And in a way, it's also this, well, it's the story of EU waste law. That there have been a lot of cases on trying to determine whether the free movement of waste, or where waste qualifications even apply to certain substances. And that's where the court has always said, basically, that is irrelevant. It's going to result into practical difficulties. What we have here are tangible objects that cross a border, and as a result of that, they are subject to the free movement of waste. So whether it's recyclable or not, they are goods within the meaning of Article 34 of the Treaty on the Functioning of the European Union, in the old numbering, Article 30.
Great, many thanks. Let's zoom a little bit more into the fact that the Wallonian waste ban was considered to be discriminatory. Mm-hmm. And if you could just give us a little bit more about this decision of the court to depart from the Danish bottle jurisprudence and the discrepancy between the two cases, the two approaches.
Mm-hmm. Well, actually, I don't think the court departed from Danish bottles. The court reiterates that imperative requirements, it's paragraph 34, can only be taken into account in the case of measures which apply without distinction to both domestic and imported products. And it refers to the Aragonesa judgment. So the court says we have a non-discrimination requirement in place, and we're going to apply it. But when you apply it, you need to determine whether you are treating like products in a like manner or unlike products in an unlike manner. That's the essence of discrimination. The essence of discrimination is to treat like products in an unlike manner or unlike products in a like manner. So the fundamental question to be answered here is really, is imported waste the same as nationally produced waste? And that's the discrimination test. And that's where the court says, precisely because of these environmental principles, the source principle and the proximity principle, waste generated nationally is not comparable, is not like waste imported, waste generated elsewhere. And that allows the court to then say, well, okay, that means that you have unlike goods. You have the nationally produced waste on the one hand, you have the imported waste on the other hand, and they are unlike goods. And if they're unlike goods, you can treat them in an unlike manner as well. And that's exactly what the Belgians had done. They had not banned the landfilling of nationally produced good, whereas they had banned the landfilling of this imported good, the imported waste. But as they're unlike products, you can treat them in an unlike manner. The interesting thing is, of course, okay, if this is a criterion to determine likeness, if you could distinguish between products on the basis of EU law that says, well, there are certain products that you shouldn't transport too much, there are certain products that you should try to be able to deal with nationally, you open up what is potentially a box of Pandora. Because there are more instances where EU law allows a member state to organize certain services or certain goods nationally. waste law is only one example. If we look at healthcare, if we look at social organization, social protection, we see similar services that are organized on a national basis, and it is allowed to do so. EU law allows a member state to do so, to organize this on a national basis. And for these services, you could then also argue, well, okay, that means that the nationally organized services is not like the same service or a functionally comparable service organized elsewhere, so we can differentiate. So that this opens up Pandora's box of potentially allowing for member states to create these national kingdoms, national waste treatment or waste management kingdoms, as I would call them. So the Netherlands takes care of its waste within the Netherlands. The Belgians take care of their waste within Belgium. The Germans take care of their waste within Germany. So it all stays within the one member state. Now, that is allowed by EU law, EU secondary law. It's also allowed by this judgment, but it does raise a couple of pretty fundamental issues. If we look at European integration, it's driven by the idea, the theory of comparative advantages. If for some reason, and I'm not just calling in random names here, if for some reason German companies or German institutions are better at recycling a certain type of waste than the Netherlands institutions are, then why should we block the export of that waste from the Netherlands to Germany? If it can be dealt with in a more environmentally friendly fashion at lower prices in Germany, then why insist on keeping it in the Netherlands? In this case, it's much the flip side of that argument. This is the case where everyone was trying to, I'm exaggerating a little bit, but everyone was trying to export their waste to Wallonia because that's where landfilling, dumping in a sense, was rather cheap. But that flip side argument is something interesting, in particular if we look at the way waste treatment is organized nowadays.
Yes, indeed. And by presenting this flip side, it's actually we're canceling the initial protective intention of the principles of self-efficiency and proximity. When we are accepting waste management which is not environmentally sound at one member state's territory, when we could export them, as you said, to another member state where the circumstances, the standards for recycling or for incineration or for any other waste management activity will be environmentally sound and at better quality at a lower price. So it's something which needs to be definitely considered because, as you said, these principles are indeed the anchors of EU waste law. And in the end, especially in the light of the circular economy policy, which is the overarching policy framework at the moment at EU level, seems to some extent to undermine the logic and the rationale behind it.
Yes, indeed. I would say that we have EU waste law. That's obvious, as we have EU health law or EU competition law, etc. But underlying this legal system, law in the books that we have at the European level, you have the actual management of the service at question or the goods at question or the processing at question. And that's where you still have a large degree of, well, national autonomy, and that national autonomy will then invariably result in national structures. And in this case, if we look at waste, it was the Belgians saying, okay, we have a national structure that we want to protect. We want to ensure that we don't have this overflow of waste into Wallonia that becomes big to such an extent that basically we won't have landfilling capacity for our nationally produced waste anymore. And that's why they banned the import. Basically, there was an excessive inflow of waste from other member states. Right now, that's turned around. Right now, everyone's trying to keep their waste at home because everyone's trying to ensure that these nationally created waste management structures have enough waste to survive, because waste treatment is a non-value added activity. even with the circular economy, we still need to, basically, there are still costs involved in treating waste. And if it's a non-value added, costful activity, basically, you want to have as much waste going through that national management scheme to ensure that you have at least the lowest per unit costs. So I guess this is where my economics background also comes into play a bit. But it makes good sense for member states to want to organize this on a national basis. But they're allowed to do so by EU law. That says you can have these national kingdoms, these national empires. Whereas, and this is probably my European background speaking, it would make much more sense to deal with this problem, the waste treatment problem, and the transition to a circular economy, the challenges that come with that, to want to deal with that at the EU level instead of at the level of the Netherlands and Germany and Belgium and France and whatever member state you have around.
Many thanks. And I think with this remark, which actually joined the dots, because a rather old case and the current state of play relating to the waste treatment at different member states at EU and at EU level, I think we are leading to the end of our podcast. That it's for today. Thanks a lot for the nice discussion, Professor Vedder. It was a true pleasure talking to you today. Thanks to everyone for tuning in. This was the 30 Years, 30 Court of Justice of the European Union Cases podcast by ERA Academy of European Law.
Thank you for having me.